Welcome to this month's Third Thursday webinar, brought to you by Synergy Settlement Services. The Third Thursday webinar is part of an ongoing free monthly webinar series. Each presentation is done by a Synergy subject matter expert who will tackle difficult issues that arise at settlement. During today's presentation, if you have questions, type them into the control panel where it says Questions. The following brief presentation will give you an overview of what Synergy does in 30 seconds.
A trial lawyer's job isn't to know all the nuances, to know what it takes to keep Medicaid in place or SSI and preserve Medicare and comply with the Medicare Secondary Payer Act and resolve these complicated liens that may be present. So all of those issues are issues that the trial lawyer really doesn't have the time or the expertise to deal with. They need a partner that they can rely upon that can handle all of those issues, and that's exactly what Synergy is.
Hello, I'm Dave Place, the Vice President and Director at Synergy Lien Resolution Services. Thank you for joining us today. We're going to talk about ERISA lien resolution, one of the most difficult topics for trial attorneys to deal with. So we're going to give you some pointers on how to address those concerns and ways to maximize the settlement dollars for your client. A little background on who I am. Before I took over as the head of Synergy's lien resolution department, I was an ERISA recovery attorney for 15 years. One of my clients is now called Equion. They're a captive client of ours, and it's been 15 years doing recovery work for the insurance industry. We switched sides, and now we bring that knowledge from the insurance world to the plaintiff's bar to try to make sure that the injury victim holds on to as much of those settlement dollars as possible. And Synergy's built our team from subrogation and recovery analysts from the insurance world who have that kind of insider knowledge. The reason we do that is important to know who you're dealing with. On the other side of the equation are recovery groups such as Optum, Equion, Conduit, and everybody's favorite, the Rawlings Group. The Rawlings Group is often the foil in all my stories. They're an excellent villain to cast in that role. You'll notice this slide here in front of you is a big, beautiful Star Trek looking building, which is the Rawlings building in LaGrange, Kentucky. LaGrange is about 20 miles northeast out of Louisville. It's a beautiful area there. And Rawlings has about 1,000 square acre campus, as you can see here. This slide, I think it's important to realize that all of those parking spaces fill every single day with highly trained subrogation examiners. That's what they do all day long, is make phone calls, place letters, and have arguments with your staff to try to get as much recovery dollars in the door. There are now about 1,400 recovery examiners at Rawlings. They built another 250,000 square feet of office space. Included in that are 75,000 square feet of subrogation training space. It's important to review this slide because often we talk to trial attorneys, the issue of liens is often pushed down to a young associate or a paralegal to, quote, deal with them. Well, this is who they're dealing with. This is a huge industry. When we were in open court for the Montanello hearing in the Supreme Court, it was admitted that just self-funded ERISA subrogation generates $1 billion a year for the recovery vendors. So we're talking real dollars. So the idea that this is a throwaway argument, something to be done after the real work is done in your case, those days are past. We're now dealing with a case after the case where you need to fight for every dollar. Otherwise, George Rawlings and his team are going to come take it. Now, George is not there in Kentucky very often. He is actually often in Palm Beach, where he bought the most expensive condo in Palm Beach history. And that's saying something, the most expensive anything in Palm Beach. Apparently, $14 million doesn't go as far as it used to because George only got the second story of this condo. But it's important to remember every dollar of that came from work you do, from injury victims. Their dollars have gone to build that. Well, not all their dollars, because George did sell his estate in LA for $20 million to the owner of the LA Dodgers. I point that out because there's some articles written this year about Mr. Rawlings, and I encourage you to read those in the Courier Journal. One is entitled "The Richest Kentuckian You've Never Heard of," and it's where these articles talk about his holdings. The next article about George Rawlings is about the way he treats their employees, which is a quite exciting read. Unless you're an employee, then it's probably all too true to read. So I encourage you to read those. As I said, Rawlings is always our foil. I think it's important to understand the tone of what they do and the mentality of what they're doing there. Their job is to send a few letters, make a few phone calls to a trial attorney, and get you to repay large portions of your settlement dollars back to the insurance industry. We're going to use some tools how to fight back on that. One of the most important tools that Rawlings uses is whenever they're the hired recovery vendor for an ERISA case, they send out a 3-page ERISA memo. This is the page 1 of it. They're not wrong. This memo goes on to detail a famous case, U.S. Aries versus McCutcheon from the Supreme Court. And in that case, the court reasoned that with perfect plan language, the ERISA plan gets repaid 100% of the amount they put out to satisfy medical benefits claims, even before the trial attorney receives his fee. At the end of the day, in this McCutcheon decision, Mr. McCutcheon was out of pocket $867 after paying the ERISA lien and after paying his attorney's fees. Now, this memo, again, isn't wrong. That is how the law works. However, it's only half the story. We're going to talk about how to push back on that and the rest of the story with what really happened in the McCutcheon decision. But first, let's do a little background on what is ERISA. We had a lot of phone calls saying, Dave, how do you know if this is an ERISA plan or not? I can't tell. Well, it's actually pretty easy to determine whether or not your client has an ERISA plan or not. If your client is receiving their insurance from their employer, it's going to be an ERISA plan, with a few exceptions. If their employer is a federal government, very likely it's a FEBA plan, Federal Employee Health Benefit Act plan. If the employer is a state government or a church hospital, or church school, then even if it is an ERISA plan, state law is going to apply. The reason being state agencies are not allowed to use a federal law like ERISA to preempt their own state law. And ERISA specifically excludes state plans from being covered. Same thing for churches, and this covers churches, church hospitals, and church schools. So ERISA, they may have a plan as a group welfare benefit plan that would seem to be organized under ERISA, but there's 2 specific exemptions for state and churches. And obviously, ERISA doesn't deal with Medicare, Medicaid, or individually purchased policies. Those be governed by a different either federal or state statute. The real question, though, when you're dealing with ERISA is how is the plan funded? Are we talking about a self-funded ERISA plan or a fully insured ERISA plan? A fully insured ERISA plan is just group insurance. Your firm or company goes out and buys a large policy from Cigna, State Farm, Aetna, whoever. That carrier bears the risk of paying claims, and any dollars recovered through subrogation reimbursement go back to that carrier. A self-funded ERISA plan is really just a gigantic savings account set up by the employer, funded by the contributions from the employer and the employee, or by the general assets of the employer. Now, when ERISA was written back in the 70s by the unions, the purpose of self-funded ERISA plans was to be a hedge against medical inflation. The idea being, if you allow these plans strong recovery rights, they would keep benefits available to all the employees and premiums low. Well, it didn't really happen. 45 years later, everybody's premiums went through the roof and all the benefits were cut. But that's the rather laudable goal of the Self-Funded ERISA Act, is to get those dollars back into the employer who can then best manage the benefits of their employees. Didn't turn out that way, but that was the goal. What's the first thing you need to do when you're dealing with an ERISA subrogation reimbursement demand? First thing you do is get all the documents that deal with their recovery rights. And there's a federal statute, 29 USC 1024B4, that deals specifically with this request. This statute allows you to make a request upon the plan administrator at any point for a copy of all the things listed here on this slide. It's an incredibly broad statute. For example, one of the things I point out is the administrative services agreement. This is one of the documents that falls in the category of other instruments under which the plan is established or operated that you're entitled to get upon this request. Now, it's important that you understand this request serves two goals. One is to give you the documents you need, but two, to create difficulty for the plan administrator and their recovery vendor. Their business model is to ride on your coattails and get paid at the end. Part of your job in fighting against the risk of subrogation reimbursement is to push them off your coattails, to make them work for their dollars. This document request serves those purposes. It is incredibly difficult to comply with this document request. It's incredibly broad. When I spent 15 years on the other side, no one in my firm ever complied with it. We provide partial compliance or no compliance, and attorneys just accept it. Things like administrative service agreement are individual documents that are difficult for the plan administrator to put their hands on. For instance, the contract between Rawlings and Aetna that the plan administrator will not have possession of. The plan administrator is the employer. So they have to make the request upon Rawlings to get that document, which they're statutorily required to provide to you. And Rawlings is going to tell them no, because there's bidding information in there. Rawlings doesn't want Optum to know their internal authority. Rawlings doesn't want Conduent to know the fees they're charging. So they don't want to provide that. So this document request has now upset the business model of the other side, where there's now a little bit of animosity between the various parties that are acting against your client. And additionally, you're getting the document you need. The document you need to be receiving is the master plan document. That is typically not the document you're receiving from the recovery vendor. Typically, you're receiving the summary plan description. And what you need is the master plan. Now, the one big trick for this document request is it has to go to the plan administrator. Sending this letter to Rawlings or Optum or Conduent will not trigger the statute. It must go to the plan administrator. If you send it to Optum, on the bottom of this slide, you'll see Optum's response, which is essentially, here's some documents. I'm not required to give you anything. Look to the plan administrator. It's important you do that because you want to trigger the statute. This is a copy of the letter we use, a very straightforward letter. I've seen these letters be 10 pages long. We like it short and sweet. In short, we don't want to do any work for the ERISA plan. We don't want to give them a checklist. We tell them what the statute requires and expect them to live up to their statutory obligations. If they don't live up to their statutory obligations, we'll let them know there is a penalty for that. That if they don't comply within 30 days, they become subject to penalties of up to $110 per day. That's important to note that these plan administrators are often unsophisticated parties. They are not in the business of dealing with subrogation claims. They're in the business of running a business. So they receive this document request from you, often ask you what you want. And our response is typically, it's inappropriate for us to provide guidance on how to honor your statutory obligations. We're in an adversarial posture. We recommend you hire counsel. The idea being, if they want some of your dollars from the injury victim, they're going to have to work to get it. Your client had to hire you to get a recovery. The recovery vendors are going to have, or plan administrators at least, are going to have to get somebody involved to prosecute their claim rather than just sending you a letter and making one phone call and expecting hundreds of thousands, if not millions of dollars to flow in their direction. Push back on them. Now, some of the penalties you'll see really add up. Now, if you do a little bit of research on this, you'll see penalties of $10 a day, $15 a day, $20 a day. But almost every week, a federal district court is assessing penalties against an ERISA plan, usually for the maximum $110 per day. That is great tool to use on the ERISA plan as leverage for why they should negotiate with you. They haven't provided all documentation. They're exposed to penalties of X dollar amount. They should be negotiating, at least removing X dollar amount from their demand because they're exposed now to penalties. The last thing we're going to cover quickly before we wrap up on ERISA is the McCutcheon case, and particularly the common fund argument. McCutcheon case, as I said, is a seminal case right now in ERISA subrogation world. And in short, Mr. McCutcheon was an airline employee who was horribly injured in an accident. made a recovery from both his UIM and the available BI. He offered to pay U.S. Airways back 2/3 of their claim. They demanded 100% repayment and took the case to the Supreme Court. At the Supreme Court level, among the issues was the issue of common fund. Justice Kagan, for the majority, wrote about a page and a half about what an anathema it is to American jurisprudence that the non-party got all their money back and the injury victim didn't get anything. As you recall earlier, Mr. McCutcheon was out of pocket $867. U.S. Airways got back all of their money, $67,000. Now, the court did say that's perfectly fine with great language, but the majority said we can't tell from the language here whether or not there should be reduction for common fund. Common fund is the idea that anybody's going to draw money out of the settlement should have paid for the creation of the settlement. Your client pays attorney's fees and cost. So the question to the ERISA plan is, what is your contribution to the common fund? In the case at hand, the majority wrote, the Supreme Court said that the settlement should, or the ERISA plan should get paid out of the recovery. And they didn't know what the recovery meant. Did it mean the gross recovery or the plaintiff's true net recovery after fees and expenses? So they remanded on that issue. What's really interesting is in the dissent, Scalia's dissent to McCutcheon, he points out that at a lower court level, all the parties had agreed by stipulation that the plan language said there'll be no contribution for fees and expenses. And the court still found that inadequate and remanded it. On remand, common fund was found to apply. This is key to understanding how common fund works and how to fight back against that Rawlings memo. Rawlings will never mention the remand. What happened on remand? Well, several things important happened, but U.S. Airways recovery was taken from $67,000 to $6,600 based upon the unavailability of UIM on the remand, but also on the common fund issue. So we treat common fund as magic words. The plan language does not say there'll be no reduction for, quote, common fund or other terms similar, like attorney fund or fund doctrine. Then that reduction should apply. Because in the McCutcheon case, simply talking about not paying fees and expenses was found inadequate. In short, we're not sending a bill to the ERISA plan for your fees and expenses. We're asking for the equitable principle of common fund to be applied. This is certainly complex information. ERISA is a complex area of law with about 20 years of federal common law surrounding their recovery rights. If you have questions or concerns with your cases you're handling or thoughts about cases in the past where you could have done things different or how to do things in the future with best practices, please reach out to Synergy. We're anxious to help trial attorneys focus on what they do best. Have a great day.